You did. Thank you. Good morning, Mr. Carroll.
Good morning, Your Honor. For the record, may it please the Court, my name is Harry Carroll, Senior Legal Counsel for the City of Springfield. I'm here with Springfield City Solicitor Edward M. Pacula. This morning what I'd like to do is to, first of all, provide the Court with a brief statement of the case, summarizing the extraordinary circumstances that lead to this argument today. Then I would like to focus the remainder of my time upon the core decisive issues in this case. In December 2008, the City of Springfield filed suit in the Suffolk County Superior Court. We sued the Massachusetts Department of Telecommunications and Cable, the DTC, which is a state agency, to ask for judicial review of what we believe to be an erroneous DTC decision. After Springfield filed suit, the legislature changed the law. Specifically, they struck paragraph 4 from Chapter 166A, Section 15. That old paragraph 4 was the one that provided exclusive original jurisdiction to the Suffolk Superior Court. What the legislature did was they took the jurisdiction from the Suffolk Superior Court and gave it to the Supreme Judicial Court for Suffolk County. The Attorney General, by way of its answer, filed the administrative record in Suffolk Superior Court and then moved to transfer the case to the single justice, to the SJC for Suffolk County.
Is this all relevant?
Excuse me?
Is this all relevant?
Well, only to the extent that I understood the rules to require that I make a statement of the case. I can go right to the decisive point if the
I think that
Court
would be helpful, Mr. Carroll.
Okay.
Thank you.
The central issue in this case involves a question of contract law. Springfield had a cable contract with Comcast Corporation. In its cable contract, there's one provision, I call it the pass-through prohibition provision. That provision consists of 2 sentences. In the first sentence, Springfield recognizes that under the Federal Cable Act, a cable operator may pass through certain costs to cable subscribers. Federal law doesn't require it, it says may. The second sentence is the key sentence, really is the focus that I think that the Court should evaluate. In that second sentence, Comcast promised not to pass through those costs, and not only promised not to pass them through, but promised not to pass them through notwithstanding any provision of law to the contrary. What happens? We go to the DTC rate hearing, and Comcast is asking for a rate hike.
Now, this is when are you going to this rate hearing? This is 2006, 7, 8?
I'm sorry, Your Honor, let me clarify. This is in June 25th of 2007.
Okay, and the contract you're talking about was executed in 1998,
August
2000?
of 1998, Your Honor. And so we go to the rate hearing, and how does this thing come up? And here is where the DTC, we believe, slipped into a number of significant administrative errors. It's what I call the multi-million-dollar mistake. What the DTC did was they assumed that this one sentence that said no pass-through of costs to subscribers was ambiguous. And the law on that has been, I think, expertly summarized really by this court in Bank versus Thermo Elemental Inc. case. And in that case, I believe the court said when you go to determine the existence of a contract ambiguity, that's a question of law for the court.
The Attorney General states that one of your claims in this regard is that it was error for the DTE, whatever it's called now, I guess the DTC, to consider the 97 settlement order at all, but that you didn't raise this at the administrative agency level and therefore it's waived. Did you raise that issue at the DTC level?
No. How the issue came up was the first of the DTC's numerous administrative errors, or by errors, what I'm talking about is a violation of the Administrative Procedures Act. And the the state regulations that require fair proceedings before administrative agencies. Specifically, it came up the day before the hearing. The hearing, as I indicated, was on June 25th.
But you didn't raise it.
No, the issue was raised by Comcast Corporation when they injected what I call the secret settlement defense into this DTC hearing the day before the hearing commenced. That's a violation of law, and they not only did that, but they injected it in the form of an unsworn answer to an interrogatory, which another violation of the administrative regulations. Answers to interrogatories supposed to be filed under oath. These were not.
All right, so let me again, I'm really trying to understand the context here. Comcast has asked for a rate increase.
Yes.
There's a hearing scheduled. Your city objects to the rate increase.
We filed a petition to intervene, Your Honor, and that petition was allowed. We became an intervening party, as it's called.
And was this the first rate increase or contested rate increase since 1998, since the signing of this cable contract?
It was the first time, as far as I'm aware, where the city of Springfield has intervened as a party. As the court's aware, Chapter 30A, Section 1, I believe it's Section 1, defines who a party is. Essentially, it provides for a three-part definition, one of which is a party whose rights are, a party who's named, as in Comcast was. They filed for the rate hearing. Another person who can be a party is a party who intervenes. So we became a party by filing a motion to intervene in the case, which we did.
That may be perfectly correct. I'm just wondering, is this something that that other rate increases had been approved in that 9-year period, but you hadn't intervened, or was
I believe that other rate increases had been approved, and this sort of goes to what I gather the defendants, the DTC and Comcast, are raising. What they say is, well, if it went on for all this period of time, why didn't you get an increase? Didn't you get a decrease earlier? Didn't you expect that? Shouldn't you have known that? And the answer is no, and the reason why is because of the way the information was reported. As the DTC found in their decision, the reporting of the information, these FRC costs, was, I believe they said, not clear. Actually, what I believe happened is they reported it as a lump sum figure, so there was no way people would know what's included in it. In other words, they hid it in the numbers.
So when you object, when you intervene and object in 2007, your objection to the rate increase was based on the 1998 contract?
Yes, exactly. We have a contract, and
what happened that made you suddenly aware that the FRCs were being increased, according to you, improperly?
Two things. One, Springfield brought on board cable contract lasts for 10 years. So we were getting to the end of the 10-year period. Springfield hired attorney Peter Epstein, who is Boston attorney that's an expert in cable rate matters, to consult with us, confer with us on this upcoming contract renewal. He brought to our attention that the FRCs were, we're being charged for stuff we shouldn't have been charged for.
So in other words, this was discoverable, you simply didn't discover it.
Well, I said two things. One thing was when we brought him on board, which I believe was in 2009. The other aspect of it was that the DTC, I believe...
That's after, 2009 is after the 2007 rate hearing.
Oh, I'm sorry. It must have been, I forget the year. I'm off on that. You're right, Your Honor. It would have been 2007 or 2006. I'm not sure of what year. It's not in the record in any event. But the second thing, though, and really the point that we're making, is that in 2004 is when the DTC required Comcast to break out these FRC rates. So instead of getting a lump sum, you said, well, here's what goes into it.
So when did they break them out? In 2005?
2005.
But you still didn't do anything until 07.
That's correct, Your Honor. And that's because we brought aboard our expert who identified it. I mean, these are not just simple papers that are all that easy to read. It's, it took us to hire an outside lawyer who's an expert in these matters. But it came to our attention, and our first opportunity, we intervened at the DTC, and we said, look, we've got this cable contract, and we've got this clause, the pass-through prohibition, and one sentence in it says, we promise not to pass through these costs to the Springfield cable subscribers, notwithstanding any other law to the contrary. But yet they had been doing that.
Well, how was that determined to be ambiguous? What was the basis?
Your Honor, it defies me. It seems like the language is plain, clear, and unambiguous. The DTC never actually analyzed it and said, we find this provision ambiguous, we find this word ambiguous. They assumed that it was ambiguous and then admitted extrinsic evidence.
Well, will this case boil down to whether we think that language is clear and obvious, or we think it's ambiguous?
That's why I indicated I believe this is the decisive issue. If the court disagrees with the position we take, and assuming arguendo, finds that it's ambiguous, we say that it's clear and unambiguous. But assuming arguendo that somehow it becomes ambiguous, then that becomes a slippery slope of a number of violations of the Administrative Procedure Act which took place at this hearing. One, no notice and an opportunity to be heard that the secret settlement was going to be an issue at the time of the hearing. As I said, it snuck its way in unsworn interrogatory answers the day before the hearing. Violation 2, during the hearing, so as it so happened, Attorney Epstein, who...
Well, can I just ask you about this unsworn affidavit? Did you object?
Yes, Your Honor. It caused, I don't know if the word objection was specifically used, but if the court reads the record, and I believe, and I've noted that in our briefs, there was certainly some consternation about unsworn answers to interrogatories being injected to secret settlement defense in the day before the hearing is to proceed. It caused some concern by the attorney, and it wasn't myself at the time who appeared at the hearing. But we soldiered on.
How was that expressed, if not in the form of an objection?
Well, I could read the transcript, but I believe that was the word objection I don't believe was used, but I think they said, we just got these answers yesterday, they're unsworn, something to that effect, and we didn't have a chance really to
Was the contract that you've spoken about, is it something that that's enforceable in a court of law?
Well, that's why we're here, Your Honor. That's why we filed suit. We filed suit because after the DTC made its decision based upon its assumption of ambiguity, we file suit seeking equitable relief from this court, actually from the Suffolk Superior Court, and as I explained, we're here because of the transfers. But seeking equitable relief, asking the court to judicially review this matter and grant an order or direct the DTC to order Comcast Corporation to refund the monies that had been overcharged to some 40,000 Springfield cable subscribers. That's the relief we're seeking.
I have an additional question, if I could.
Yeah, of course.
I'd like to ask you, Mr. Carroll, the Attorney General says that you raised the question whether the application of the agreement, the settlement, and the order required a promulgation of a regulation because the DTC was going to give it general effect, and the Attorney General says that you didn't raise that before the DTC either, and therefore it's waived. Is that correct, that you did not raise that before the DTC?
It was not specifically raised in those terms. Certainly the secret settlement, once the DTC allowed Comcast to inject it there, was mentioned, but the DTC in another violation didn't even put it on the record. It's not in the record. It came in after the hearing. And as a matter of fact, it not only came in after the hearing, it came in the decision of the DTC itself when they took administrative notice of it. That's how it came in, and that was without giving Springfield an opportunity to know that they were going to take administrative notice and be heard on it. 2 more violations of the Administrative Procedures Act.
The settlement agreement, which you call a secret settlement agreement, is the 1997 settlement agreement?
Yes, Your Honor.
And when did you first become aware of that agreement?
We became aware of it after we brought Attorney Epstein on board that there was such a thing. There were some letters back and forth, but we became aware that it was going to be part of this rate hearing the day before the hearing when Comcast filed its unsworn answers to our interrogatories.
Assuming that you'd had the most competent counsel all the way through, when could you have obtained access to that document?
Well, Your Honor, that's an excellent question, and I don't think as a practical matter it could have been done, and here's the reason
But wait a minute, wasn't the order that the DTC issued based on that settlement agreement?
It was, Your Honor.
Well,
So
that's
it's a public record.
But it's where? Where is it, Your Honor?
Right.
Well, we're talking about the 1997
The
agreement.
1997. Springfield was not a party to that. That's the first thing you need to know. We didn't know about it.
I understand that.
We
I
didn't get a
understand.
copy of it. And here's a perfect example for this case, and I see my time is being exhausted, or is exhausted. But in this case, the Attorney General puts a footnote in his brief, and he mentions the federal case, which is another case that where Springfield sued Comcast in state court, and then Comcast removed it to federal court. It's pending. And the Attorney General says that in that now federal case, the federal judge dismissed some of the counts. And that's true. But what DTC did not know is that, because they're not a party to the case, is after that, both parties filed a motion to reconsider, and the judge vacated his order pending the outcome of this decision. And what that means, and what that point is that just as Springfield didn't know about this secret settlement, the Attorney General's office didn't know about what is a public record, a federal court decision involving this case that they cited in the brief. If they did, they wouldn't have misrepresented, or at least they would, I'm sure, would have clarified that these issues weren't dismissed, these counts weren't dismissed, that the dismissal had been vacated. And that information is in the record. In summary, or too late for a summary?
Too late for summary.
Well, thank you very much.
It's very
Your Honor.
difficult to summarize one of these cases, so thank you, Mr.
Thank you, Your
Carroll.
Honor.
Mr. Barnico?
Good morning, Your Honor, and may it please the Court. My name is Thomas Barnico, Assistant Attorney General, and I represent the Department of Telecommunications and Cable in this case. I'd first like to categorize the various claims that have been made by Springfield, then offer our view as to what needs to be decided today and what may not. Plaintiff makes three types of claims. One is, I believe, to be a straightforward substantial evidence claim, seeking review of the department's decision construing the 1998 renewal license.
I have a question about that, though. Are you approaching this as an ambiguity, and as an ambiguous order on which the DTC took evidence and then decided on the basis of evidence that the Comcast was right and that satisfied the substantial evidence test? Or are you saying that the 97 agreement and order were not ambiguous, in which case DTE's interpretation, I think, would be just a question of law, and DTE's decision is either right or wrong and the substantial evidence test wouldn't apply? So what I'm asking you is, are you conceding that the settlement and order were ambiguous, or are you saying they weren't? Because I read both things out of your brief.
Yeah, that's because I think the DTC said both. I think they, at various times in the decision, they considered the reference to pass-through in the 1998 renewal license to be so clear a term in this regulated industry as to be alone aground. But in the alternative, then, of course, they did consider extrinsic evidence.
So your position is that the order is not ambiguous, and as a question of, as a matter of law, it was correctly decided, but if it is ambiguous, there was substantial evidence to support?
Not quite, Your Honor. In
No?
fact, I think in this context, the decision is reviewable under the substantial evidence question in both respects. I don't agree that you simply take contract law principles and apply them without any modification to this type of situation. After all, the review of the rates is under the statutory authority and the reasonableness and discrimination and all the rest. There arose within that proceeding a question about that involved a contract and its interpretation. But whether it's a question of clear language, namely pass-through, or an ambiguity in the same language, I think you get to the same place in terms of the standard of review by this court of the determination. So I don't accept his premise
Mr.
about
Barnico,
the...
help me.
Right.
Right? Springfield says, look, we had a deal with Comcast.
Right. That's correct.
The department knew about the quote deal?
The renewal, well, the
I'm
deal...
just
Right.
trying to figure out, we've got the department and Comcast, and we've got Springfield and
Right.
Comcast, and I'm trying to figure out where they intersect.
Right, well, certainly everyone intersected in June of '08 for that
No, I
hearing.
understand that. I'm trying to going back to 1997.
Right, in 1997, we don't argue that Springfield was a party to
No,
the...
I know
Right.
that. I know that.
Well, then in '98, you have a renewal license agreement between
Right.
the city and Comcast. I'm not sure whether those are filed as a routine matter with the DTC. That is the agreement that governed the relationship between the city and Comcast going forward for a 10-year period.
Right.
Right. And there later arose, on Springfield's motion, a question as to the interpretation of one term in that 1998 renewal license agreement, and that was the pass-through prohibition that Mr. Carroll described. I think an important marker along the way, because there was, I think, still a little confusion about the chronology. And the relevant chronology, I think, is to start the 1997 order that approved the Comcast settlement agreement. That's 1997.
Comcast settlement agreement with...
It appears to involve multiple municipalities.
It's subscribers. It's,
Yes.
Yeah.
And
And the
municipalities.
DTC approves that.
Yes, as a public order.
Right.
And becoming part of a series of orders issued by the department regarding Comcast. 1998 comes along, and there's the renewal license entered after negotiations with Comcast and Springfield.
Yeah.
Then there arose, in response to an earlier order, a series of annual rate cases in which Comcast applies, and in some of those cases, some cities intervene and some don't. Most telling, we think, is the 06 order, which is we've provided to the court,
Yeah.
which specifically discusses this pass-through question and becomes the previous order of the DTC that's cited in a footnote in this decision that's under review.
Could
And
you
the
point-
reason
could you-
why that's important, Your Honor, is that because that order specifically grants a refund to Springfield, among others. Now, Springfield wasn't a party to the 06 case, but that's about as close as you can get, that
The notice.
there's actual notice, exactly.
Well, would it matter if actual notice, if it's a public record?
We argue no, that there was presumptive notice of the 97 order all along. It governed Comcast, and so that we argue that there's a presumption of knowledge right along. But 06 comes along and you come extremely close to actual notice. Then you enter the sequence of the 07 petition for rates and the 08 hearing.
So you're saying, if I get this straight, in 2006, there was an order that considered the pass-through agreement, and the order granted a refund to customers or subscribers.
Including
On
Springfield?
various grounds, not this,
Not
but
this.
including Springfield.
Okay.
So Springfield specifically named in the 06 order, which in other sections of the same order discusses this same problem and construes pass-through and as exactly the same way, namely applying only to so-called incremental costs,
Right.
new costs year to year. So
Is that an
06,
appealable order
that was appealable order.
by the city of Springfield?
Well, they didn't intervene
not a
as
party.
a party,
Oh.
right.
But do you agree that if Springfield had entered into a contract with Comcast, which said for the 10-year subscription period, Comcast may not pass through any cost, this means not merely incremental, but also embedded costs, that the DTC would have had to honor that agreement?
Yes, I think that is a matter of contract in the bargaining. Comcast and the city could have bargained over various matters, including the removal of certain money from the embedded rates, the historical rates, or some other trade that would have the same effect.
So if it is clear and ambiguous, then, and there was not substantial evidence to find the ambiguity, then you would lose.
Well, I put it just slightly differently. No reasonable mind could conclude that the agreement, you'd have to say that no reasonable mind looking at that agreement or looking at the agreement plus could conclude that it didn't apply to the embedded costs.
Don't you win if no reasonable mind could find it to be ambiguous? As long as there is
Well, it'd have to
substantial
be-
evidence that it was ambiguous.
You'd have to decide, you'd have to decide that, of course, one way for the DTC to be affirmed is for you to decide that it's absolutely clear and the DTC's right. that
Okay,
pass-through
I understand that,
money.
but you can also win if we were to say we agree that it's a reasonable position to take that it was ambiguous, and in view of the extrinsic evidence, that it should be applied only to incremental and not embedded.
Yes.
But if it's absolutely clear, isn't that a matter of law on which no evidence is necessary?
I don't know that the DTC is bound by that principle, Your Honor. That's where I'm pausing before agreeing with the plaintiff on that score. That is, the rules of evidence don't apply.
Right?
Contractual matters come before agencies from time to time, particularly in a regulated industry. But the beacon
But the
is always...
DTE is bound by Chapter 30A. You don't have
Yes.
DTC, yeah.
Right, which
Yeah.
does not require the rules of evidence.
Right.
And so I think it still boils down to a substantial evidence case, and that's a good place to end, because I think that's the only issue that the court needs to reach.
Yeah.
Every procedural objection that has been made against the use of the 97 order has been waived. Whatever you can say about the late arrival of interrogatories, there was a full-blown hearing over the meaning of the 97 order, and an opportunity in post-trial briefing to address any of these procedural objections to the use of the 97 order. None of that was made until the blue brief in this court, so they're all waived. So, too, any of the constitutional claims have been waived or have fundamental flaws based on the Spence doctrine. So I think the only question the court really needs to reach on the merits is what I'm calling the substantial evidence question on the interpretation of the 98 agreement.
And just tell me one more time why I look at it as which is the way you've argued it, as a reasonable minds couldn't disagree, as opposed to there's no ambiguity.
that so long as a reasonable mind could consider it clear in Comcast's favor, or a reasonable mind could consider it ambiguous, but decide for Comcast on the extrinsic, then the
But why do we apply the 30A standard to contract interpretation and not the common law standard? It's a question of law for the court to decide whether there's an ambiguity.
Because this is a statutory proceeding from beginning to end. It arrives at the doorstep of the DCC on the question of whether rates are reasonable, non-discriminatory, and all the rest.
Was that contract enforceable in, for instance, the District Court of Springfield?
I think it may be a contract separately enforceable, well, alleged to be enforceable in a common law setting. That's what Springfield has done in the case that was removed to federal court. But that doesn't mean that contract principles without modification are applied on judicial review
Of a
of a
30A.
statutory decision by an agency applying a statutory standard
For
like
purposes of
reasonable
rate
rates.
setting.
Yes.
All right.
Okay.
Thank you very much.
Thank you, Mr. Barnaker. Mr. Caldwell?
Good morning. May it please the Court, Adam Caldwell on behalf of Intervenor Appellee Comcast. And the good news is I got to sit and listen to it all. The bad news is now I don't know where to start because so much was said. But let me start sort of where we ended, and let's not lose sight of the fact that this was a rate case. It's not just a simple case at law involving contract interpretation. It's a cable rate case. They're done every year at the DTC. Each year, Comcast makes a rate filing. And so this is a highly specialized contract that involves a vast regulatory regime at both the federal and state level. And the interpretation of this contract is within the DTC's expertise and judgment and specialized, and where it specializes.
Well, are you suggesting that DTC can simply ignore this contract term and say we're not going to apply it? Or
No, it did quite the opposite of that, because what the DTC understands is also what the FCC would understand about this, which is this. When Comcast says in a contract, we will agree not to pass through
any of the
franchise-related
following costs, A, B, C, and D.
That's correct. What that means is you can only give up what you have, okay? So if we start from that premise, Comcast only has the right to pass through incremental FRCs. Those are the franchise-related costs that exceed the costs that were in Comcast's prior licenses with the city. Okay, when cable rate regulation came in 1992 and 1993, the FCC, in implementing Congress' intent, had to do something with franchise-related costs that existed in existing franchises. And this franchise went back initially to 1982, ran to 1997, then was renewed. And what the FCC said was that we will treat pre-regulation franchise-related costs as embedded in rates, and only post-regulation franchise-related costs may be passed through to subscribers. So pass-through is a term of art that applies only to incremental franchise-related costs. Now, with that understanding,
Well, couldn't they have explained all of that in this provision?
they could have, but there was no need to. It would have been completely redundant. And I feel compelled, it's normally not a good argument strategy to tell the court that we've said that we don't think this is in the right place. We think this should be at the FCC. Comcast has made a preemption argument that all rate appeals, all cable...
But this is, federal law would apply if there were an enforcement, but there's no enforcement here. It's just, as you said, a state rate-making case.
No, the state rate-making, the state DTC, by becoming a rate regulator, says we will comply with the FCC rate regulations.
Comply, but this is not an enforcement action. And federal law would preempt if it were an enforcement action.
Well, what the federal law says is that all rate appeals that involve whether or not the rate authority acted consistently with the Cable Act of 1992 and with the FCC regulations If that question is raised in an appeal, it must go to the FCC. If that question is not raised, then it may go to state court. So the question is, and I admit it's an interesting question in this case, is whether or not this appeal involves whether or not the DTC acted consistently with the Cable Act and the FCC. You could say, well, this is just contract interpretation, but it's really not, because you need the full panoply of rate
But then every
background.
DTC rate-making case could be dragged into federal court. Every one.
All they really should be, and there are
But
hundreds.
they aren't.
There are hundreds and hundreds of FCC of rate appeals that go to the FCC.
Well, correct, but we also hear them.
That's true. So some can and some can. And I don't want to get tied up in preemption, because what I want to stress to the court is that there's no question that Comcast honored this agreement.
Mr. Caldwell, let me ask you about this agreement. Is this agreement enforceable in a court of law? Totally apart from these rate-setting proceedings?
There are procedures by which a franchising authority, such as the city, and it is a franchising authority, can send notices of default, which it did, in relation to. Yes.
But what I'm really getting at is, so it's entirely possible. There's a scenario whereby a court of law would be applying some common law rule to the interpretation of this contract, and for purposes of the context of this rate-setting proceeding, the administrative agency will apply a substantial evidence test to this contract, and we have to honor that.
Yes.
And they could be there could be inconsistent constructions of this contract.
It's vital that in this instance, that whether or not you might take a different interpretation, that you should defer to the DTC's interpretation of the agreement.
In the context of the rate-setting proceeding.
Of a rate setting. Now, Comcast honored the agreement. It never passed through incremental FRCs. And there's a memo from 1998 about the time that this contract was signed, where the city says you will not pass through franchise-related costs such that cable subscribers' rates will not increase, and in fact they did not. With respect to the 1997 settlement, that arose in a rate proceeding, and the city gets notice of every Comcast rate proceeding. The city got notice of that proceeding, and the city then got notice of the 1997 order. It doesn't want to remember that fact now, but that can be presumed. It gets notice of all of the rate proceedings just as it did here. So there was absolutely no surprise about that. And with respect to, so going back, there was no surprise. They had notice of it. And then with respect to how it was raised, if I may, in this proceeding, the interrogatory answers that counsel referred to, they asked for those. They served those on June 10th and asked for Comcast to respond by June 24th, which is when Comcast responded. And Comcast had no obligation to, because under the rules there, they would have had 30 days, and frankly, the city was required to seek leave to serve those interrogatories and did not.
Thank you, Mr.
Thank you.
Caldwell. We'll take a short break.